So a California judge has ruled that the families and victims of the Poway Synagogue San Diego shooting can sue Smith and Wesson as well as a San Diego gun store. So let's talk about this. But real quick before we jump into this video, if you think that we should actually hold criminals accountable instead of the gun manufacturers, go ahead and hit that like button and subscribe. I also want to give a shout out to one of the main sponsors of the channel, and that is USCCA. Through your membership, you get training, education, and self-defense liability protection. So if you're in the market for something like that, if you carry a firearm, I highly recommend you take a look into USCCA, and I'll put a link to them down in the details section. The case we're going to be talking about in this video is Goldstein v. Ernest, and this case stems out of a shooting that took place at the Poway Synagogue on the last day of Passover on April 2019. And unfortunately, out of that shooting, one person did pass away and others were injured. Well, this lawsuit was instituted against Smith and Wesson as well as against a San Diego gun store because that criminal acquired a Smith and Wesson rifle and used that rifle during the shooting. Plaintiffs in this case are of course backed by the Brady campaign, and they allege that Smith and Wesson marketed, manufactured, distributed, and ultimately sold through that San Diego gun store a rifle that was used in that shooting. The plaintiffs also allege that this rifle was made in a way that it is easily modified into what they state is a military style assault rifle, and in a way that could make it a machine gun in violation of federal law as well as California law. The plaintiffs also allege, and this is coming directly from the court order, that the gun was marketed to a 19-year-old shooter who did not have a valid hunting license that would have allowed him to buy the gun. So those are the allegations against Smith and Wesson, that they sold, marketed, distributed this rifle that could be converted into a military-style automatic rifle in violation of federal law and California law, as well as they marketed this rifle to an individual who is 19 years old. And then there are allegations against the gun store itself. And against the gun store, what they allege is that the gun store violated California laws by selling a rifle to a 19-year-old without a hunting license. So in the state of California, individuals under the age of 21 can only acquire certain rifles and other items if they have hunting licenses. And here what they're alleging is that this 19-year-old did not have a hunting license. Now, a little bit of nuance here. Actually, when you read the complaint in the order, what really happened is that this 19-year-old did have a hunting license, but it didn't go into effect, I believe, until a later month. So there was a procedural error is what it appears to be on the behalf of the gun store in not confirming that it was a valid hunting license as of that time. They sold this rifle to this individual and he went and committed atrocious criminal activities at that synagogue. And now the plaintiffs are suing this gun store and trying to hold them liable for those actions. There are also some allegations against the gun store that they knew that this MMP 15 series AR-15 style gun could be easily modified to fire automatically. This is kind of where this whole case gets really weird and where the judge's ruling gets really weird. And we're going to talk about this, but there's allegations against Smith and Wesson that they knew that people could modify these to be automatics and do it in an illegal way. And then there's those same allegations against this gun store. Now let's take a look at what the judge actually ruled. And one of the main issues out of this whole case and why it's on a lot of people's radar is because this ruling by this judge goes directly against a federal law which preempts these types of actions known as the PLCAA. The PLCAA, also the Protection of Lawful Commerce in Arms Act, is a federal law that pretty much protects gun manufacturers and gun stores from being sued and held liable for actions of third-party criminals. So under the PLCAA, you cannot bring a qualified civil liability action against a gun manufacturer or a gun store. A qualified civil liability action is as follows. A civil action brought by any person against a manufacturer or seller of a qualified product for damages, injunctive or declaratory relief, abatement, restitution, fines or penalties, or other relief resulting from the criminal or unlawful misuse of a qualified product by the person or a third party. Similar to how we talk about all the time, you cannot sue Ford because someone drives drunk with their vehicle and causes an accident. You couldn't then go sue Ford. You couldn't then go sue the alcohol manufacturer. You couldn't do a lot of these things in other industries. You don't go after the manufacturer because someone engages in criminal misconduct. You go after that actual individual. Now, of course, this doesn't insulate gun manufacturers or other industries for that matter from things like negligence or product defects. So you could always still sue them for things like that. Well, that's exactly what this lawsuit is. And the judge here uses some really baffling logic to try and get around this whole issue by fitting this case in what is called the predicate exception provision of the PLCAA. The predicate exception permits actions where a manufacturer or seller knowingly violated a state or federal statute applicable to the sale or marketing of the product where the violation proximately caused the harm sued upon. So there are exceptions to the PLCAA, and that is where the judge is trying to fit this lawsuit into. And how this judge does this first is by stating that Smith and Wesson was negligent in their marketing. In the judge's order, he talks about that Smith and Wesson marketed their rifle to individuals underage in a way that's kind of video game-esque and would make these young individuals want these rifles and want to go out and commit these types of atrocious activities, which is really interesting because I'm unsure when we moved back to this whole lame argument that video games are responsible for young kids committing violence. I thought we got rid of those arguments a long time ago because they're just absolutely absurd, but this judge, I guess, didn't get the message and is using that again. Then he also states that it fits under this exception because Smith & Wesson knew that this AR-15 style gun could be modified to be fully automatic in violation of federal as well as California state laws. Now, one thing to note, I'm not aware that this individual actually modified the rifle. I didn't see anything in the documents. I could be wrong, but it doesn't necessarily even matter. In the same way, we wouldn't try to hold Honda liable for someone modifying their Honda Civic in a way that it violates California laws or federal laws, making street mods on whatever their Honda Civic or whatever car. You wouldn't try to hold those car manufacturers liable for those types of modifications, but here this judge says, no, we can do that when it comes to gun manufacturers. Now let's take a look at the gun store. And when it comes to the gun store, I think there's much more of a legitimate argument against the gun store because like I mentioned, they did sell the rifle to this 19-year-old individual who did not have a valid hunting license. Under California law, you needed that hunting license to purchase that rifle. They didn't check that date on that hunting license or they just ignored it. I'm not sure what really happened there, but there was not a valid hunting license. It didn't take effect, I believe, until months later. So they sold this rifle to this individual when they weren't supposed to under California law. So here I think there is a much stronger argument against the gun store, and so I understand why this case proceeded forward against the gun store. That doesn't mean I agree with this. I think 18, 19, 20-year-olds should be able to purchase any type of firearm they want without any type of restriction. I think if you can go to war, if you can get married, if you can enter into contracts, you should be able to purchase firearms just like everyone else. But the state of California has specific laws when it comes to you needing a hunting license, and it seems like this gun store did not follow the proper procedures, and so that's why this case survived against them. However, there was one interesting thing, like I mentioned in the intro against the gun store, is they also said that this would fall under the PLCAA exception that we talked about before because the gun store sold this M&P15 to this 19-year-old, and this is the type of rifle that could be easily modified into what the court claimed to be a fully automatic style rifle or a military style rifle. So here they're trying to hold the gun store liable because someone can engage in criminal modifications to a rifle, and really that would make almost any single type of rifle sold across the US fall under this type of exception and would allow anyone in any state to sue any gun manufacturer that sells AR-style rifles because there's nothing special about the M&P15. It is very similar to any other type of AR-15 style rifle that is sold out there. So again, this is a really weird way that this judge is addressing this. It is just a straight up violation of the PLCAA. It directly tries to circumvent that language. And again, he's trying to fit a square peg into a round hole because, in my opinion, he is clearly biased based on his ruling. So if you guys have any questions, go ahead and comment down below and I'll try to answer the best of my ability. Also, if you like this video and like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm. It helps to signal to YouTube that you guys see value in these videos, in this type of 2A news, and then it pushes it to more individuals. I cannot thank you guys enough for everybody that's commenting down below. If you look at my last few videos, you can see that you guys who are commenting, liking, subscribing, all of that, you are having a huge impact on my videos. It is pushing it to more individuals, and I cannot thank you guys enough. So go ahead, if you don't have a comment you want to drop, just comment, hey, I'm commenting to fuel the algorithm, or I'm commenting to fuel Al Gore's rhythm. A lot of people like commenting that. I really appreciate it, and it really does help these videos. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars and state will be maintained by armed scholars.